Hello, my name is Benjamin Hart. I'm an American attorney and managing director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to be discussing the K-1 Fiancée visa, specifically the marriage requirement for said visa in the United States for purposes of adjustment of status. For more information on adjustment of status specifically, there's another video on this channel, and we go into adjustment issues in more detail. But suffice it to say, for the purposes of this video, adjustment of status is basically the process by which a K-1 fiancé comes to the United States, marries their American citizen counterpart, and then goes ahead and applies to adjust into quote-unquote green card status or lawful permanent residence. So the question posed by this video, as the title suggests, is what happens if we don't marry? This isn't an overly frequent occurrence, but it is an occurrence that can happen. And it basically revolves around the fact that what you'll see is either changed circumstances or maybe the couple turns out to be incompatible. It's not something folks like to foresee, and it's not something most folks like to go through, but this can occur. So basically, the type of scenario we're looking at is, okay, the couple has gone through the K-1 visa process, they've obtained their K-1 visa, and they've come to the United States. At that point, circumstances change. In some cases, circumstances may change and it doesn't have anything to do with the underlying relationship. The underlying relationship is sound. It's just due to career reasons, family reasons, emergencies come up, what have you. The couple decides not to marry in the United States. Well, what happens in that case? So long as the K-1 fiancé, the foreign fiancé, leaves within the 90-day period, leaves the United States within the 90-day period, it's essentially a no harm, no foul situation. So not getting married and not adjusting to status is not a bad thing per se, but it needs to be dealt with within the scope, the narrow scope of the visa concern, i.e. the 90-day period. You got to make sure you don't overstay that 90 days, otherwise an overstay bar can be triggered, and there's another video on this channel with respect to grounds of inadmissibility and overstay. But to sum up this video, just for those viewers who came here to learn what happens if we decide not to get married, well, basically no harm, no foul. As long as the foreign fiancé leaves the United States before the 90-day expiration of the underlying visa. Let's be clear about one thing though. Intent is important. The couple must have the intention to marry at the time they file and at the time they're processing the K-1 fiancé visa application and petition. So for that reason, just because a K-1 fiancé didn't marry, that's not a deal killer for later situations. But if it could be determined that the K-1 fiancé was used as sort of a pretextual measure, as sort of just a way of getting in the United States, and that the intentions were not genuine at the time of filing and processing, that opens another kettle of fish, and you could possibly see a situation where you've got a fraud and misrepresentation ground of inadmissibility associated with that K-1. This is probably infrequent. In most situations, nobody's going to go through the process of going through all the K-1 hurdles only to get the United States for 90 days. It's not a huge amount of time. But that being said, it does happen. How do you deal with it? Well, as I've said, as long as the foreign fiancé leaves within the 90-day period, it's sort of a no harm, no foul situation. That being said, under the provisions of IMBRA, the International Marriage Broker Regulation Act, there are certain regulations with respect to multiple filings, and I have another video on this channel with respect to multiple filings of visa petitions and how it impacts later petitions. And for more information on that, I suggest going to that video on this channel.